client, but here's the thing. He put himself in a box when he said, my client's damaged.
To get a search warrant, you have to have probable cause that a crime's been committed and there's evidence in a particular place.
Knowing what a prosecutor must prove at trial is critical to understanding how to beat criminal restraint charges. Whether it's an indictable crime at the Superior Court Criminal Division, predicate act in the family part as a predicate act of a restraining order. Either way, each criminal restraint charge has elements that is required to be proven by a reasonable doubt in the criminal context or preponderance of the evidence in the family part. See, at the Bianchi Law Group, we are a team of former prosecutors, and we use at the onset of all of our cases the model jury in charge. Model jury in charges are instructions. It's really breaking down the law for each and every crime or offense to be used at the end of a jury trial to be presented to the jury to instruct them on what the law or the elements are. You see, jurors, they're lay people. They didn't go to law school. They don't have any training whatsoever when it comes to the law. So we as lawyers in the courts have to put together these jury instructions to educate the jurors as to how they need to apply the facts that they hear at trial and decide whether or not somebody is guilty or innocent. See, the stakes are high. For a criminal restraint charge, there's prison time. Defendants are exposed to up to 5 years in prison on that charge. So when we are defending our clients with criminal restraint charges, it's critical that we explain to them exactly what needs to be proven so that they can assist in their defense. How could you assist in your defense without understanding what needs to be proven? And unfortunately, in our experience as prosecutors, and even some of our colleagues on the defense side, they never go through these painstaking details with their clients. So we do. I'll talk about John. John is a former client of the Bianchi Law Groups, and John spent 210 days in jail. See, he had a lawyer before us. The lawyer didn't know the elements of the aggravated assault statute. Second degree requires serious bodily injury. I will define that later in this video for criminal restraint. But the element of serious bodily injury on that aggravated assault charge against John couldn't be proven. Wasn't supported by the evidence, wasn't supported by the medical records in the file. So when John came to us and hired us, and we substituted in his counsel for his prior attorney, we immediately identified the fact that the prosecutor could not prove serious bodily injury, brought it to their attention, got him out of jail, and we resolved that case. It was a pretrial intervention resolution. Important to know what goes into the charges so that you or your attorney can help dismiss the charges. We're located in Parsippany, New Jersey. We handle criminal defense, domestic violence, and municipal court cases. See, when Bob Bianchi and I opened up this firm in 2013, we understood the importance of having experience as a prosecutor. The best criminal defense attorneys are former prosecutors. Why? Because as former prosecutors, you cut your teeth on the code, you learn the elements of the offenses, you stand up at a young age and try cases before juries. Now, don't get me wrong, not every former prosecutor is equal. I'm a former homicide prosecutor. My partner, Bob Bianchi, is the former head county prosecutor of Morris County. And we put this firm together by employing exclusively former prosecutors. Even our paralegal at the Bianchi Law Group is a retired law enforcement officer. So we've identified the importance of being on the other side to effectively and efficiently representing our clients at our criminal defense firm. So let's talk about criminal restraint. Criminal restraint is codified in 2C:13-2A. Person is guilty of criminal restraint if he knowingly restrains another unlawfully in circumstances exposing the other to the risk of serious bodily injury. As I stated at the Bianchi Law Group, we use these model jury instructions. And I am going to show you the model jury instruction on criminal restraint now. I will also put a link in the YouTube description to this model jury charge. And I will also provide an ebook, a free ebook written by our team of former prosecutors, which is Understanding the Criminal Justice System in New Jersey. That ebook will go through the stages of prosecution from the moment of arrest to conviction at the end of the case or dismissal and the various different options of disposition. So if you need more information, you could download the instruction on criminal restraint, download our free ebook on Understanding the Criminal Justice System. There's also a consultation link there where you could click the link and schedule a consultation, or you could call us at the Bianchi Law Group, 862-210-8570. Take a look, learn about our firm. So looking at the criminal restraint model jury instruction here. As I said, here's the text of the statute. And then underneath it, you will see the 3 elements that's required. Now, there's another video I did on this, similar. It's called the lesser included of false imprisonment. It has both the first and second elements the same. It's just the third that's different. So in the false imprisonment element, it requires that the restraint interfered substantially with the victim's liberty. Here, it requires that the restraint was under certain circumstances in which the defendant knowingly exposed victim to the risk of serious bodily injury. So the way that this happens actually is because the criminal restraint is an indictable crime, that could be charged. And if you go to trial on the criminal restraint, at the end of the case, the jury will get the lesser included false imprisonment. It's considered a lesser included because it has the same elements, 1 and 2. There's one off, and it's considered lesser. It's a disorderly person's offense. So if you go to trial on the criminal restraint, the jury will get the law on the lesser included false imprisonment. But here, this is the jury charge on criminal restraint, and it goes into the elements. First, that the defendant knowingly restrained victim. And then even here, if you look a little bit lower, the next paragraph, it defines restraint. The word restraint means confinement, abridgment, or limitation. Restraint involves hindrance, confinement, or restriction of liberty. Right? So first element, the defendant knowingly restrained victim. Second element, that the defendant knew the restraint was unlawful. Still, the restraint has to be unlawful. Now, let's just say a perpetrator comes into your home and tries to steal your property, and you go and restrain him, call the police so that you hold him until the police come. While that may be a restraint, it's not an unlawful restraint because you have every right to hold him there. Is that safe? No. Do I recommend it? No. But to illustrate the point that the restraint needs to be unlawful, it just shows a restraint that the person would be lawful doing. The third element, that the restraint was under circumstances in which the defendant knowingly exposed the victim to the risk of serious bodily injury. Again, that's the difference between the false imprisonment and the criminal restraint. So to know a little bit more about that element, or any for that matter, you scroll down to the third element here. Let me just minimize the screen a little bit so you can see the whole thing. All right, it goes on. It copies the language that we read above on the elements, but it also defines serious bodily injury. This is important. This is the John issue, right, that I talked about, that the prosecutor didn't have the serious bodily injury in the medical records or couldn't prove the attempt to cause serious bodily injury here. What is serious bodily injury? It's defined here. It means bodily injury, which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the functions of any bodily member or organ. And then on the jury instruction, it gives you a footnote. And you scroll down and take a look at the footnote. This is where the definition is. That's the homicide statute in the state of New Jersey. So it's really important to not only understand the elements of the offenses, but also to understand what the definitions are. And sometimes those definitions may not be in the statute itself. You may have to look to other statutes to find out what those elements are, like here, right? So as I stated before, it's critical to understand what needs to be proven here. At the Bianchi Law Group, we send out a welcome package that includes the statutes, jury instructions, so that at the onset, our clients understand what the law is. It's also critical when evaluating whether or not a plea offer is reasonable or not. Oftentimes in criminal cases, prosecutors will extend plea offers to resolve the case without going to trial. And sometimes they're to plead to the offense themselves with a recommendation of a sentence to go with it. Sometimes they amend the charges to lesser includeds or others. Either way, it is critical to understand for plea bargains, whether to go to trial or not. Very life-changing, important decisions, what needs to be proven. And it all relates back to understanding, going over with your lawyer, and also spending the time to dissect the evidence to determine whether or not the charge is provable. Again, I'm David Bruno from the Bianchi Law Group. Next, you will see, if you just follow this video to the end, I will put up a video, how to choose a criminal defense attorney, by my law partner, Robert Bianchi, the former Morris County prosecutor. And I'll give you a quick hint. That's the Bianchi Law Group. Yeah, why? Because we're a team of former prosecutors. Our partners are certified by the New Jersey Supreme Court as criminal trial attorneys. We have a team approach. We're empathetic. Our values, our core values, our courage, the courage to stand up to our adversaries and the courts, compassion to help our clients in the lowest points of their lives, and commitment. We commit to squeeze every last drop, explore every legal issue, and try to get the best possible disposition we can on each and every case. If you have any questions about this video or anything, need representation, have questions about an investigation or your charges, call us at 862-210-8570. Go to the website, BianchiLawGroup.com, download the ebook, download the jury charge, give us a call. We are here to help you. Hope you enjoyed this video, and please like, share, and subscribe.